we will start with the Magna Carta because that's the most known such legal document, and Sir John Hamilton Baker from the Cambridge University will have an online presentation about the Magna Carta.
Magna Carta, Charter of the Liberties of England, has two histories. One is the story of what happened in and before its issue in 1215. And the second is the story of why it became so important later. Now, given the context of this conference, I shall spend more time on the first story, which concerns the reign of King John. John became King of England in 1199. His grandfather, Henry II, had ruled not only England, but a vast French empire, including Anjou, Normandy and Aquitaine, and had spent more than half his reign in France, while his successor, Richard I, hardly spent any time in England at all. And during their reigns, which spanned the whole second half of the 12th century, a permanent law court settled at Westminster, acting in the king's name, which had begun to establish a regular system of common law, through which property rights could be more settled than they had been. However, both the Plantagenet Empire and the rule of law in England were falling apart under John. Historians have had difficulty finding much good to say about John. He had grabbed the throne on the death of his eldest brother, Richard, even though his nephew, Arthur, Duke of Brittany, had a stronger claim. And when Arthur mysteriously disappeared after being captured by John's forces in 1203, it was widely believed that John had arranged his murder. The French king, Philip II, seized upon this as a pretext for expelling John from his French possessions, and that was accomplished in 1204. John, after that, lived in England, taking over the day-to-day government, the first resident king for decades. And the fixed court of law at Westminster ceased to exist. John then ruled in an autocratic, even despotic manner. Although his excesses were not wholly without parallel in the previous century, they were largely beyond the reach of the legal system because they exploited recognized but ill-defined royal privileges. Desperate as he was to raise sufficient funds to finance the recapture of his French empire and to support his expensive lifestyle, he resorted to abusing his feudal rights. Heirs were made to pay exorbitant sums to take up their inheritances, and their lands were stripped of assets while they were in the king's custody. Extortionate taxes were imposed. More and more land was declared to be royal forest, which removed it from the ambit of the common law and brought the king a huge income in fines. Church lands were exploited during vacancies in bishoprics, and large sums were demanded for elected bishops to enter their sees. Such rapacious abuses, coupled with an unreliable character, made King John deeply unpopular among the baronage and the episcopacy alike. But things only became worse when John antagonized Pope Innocent III by refusing to accept his nominee, the theological scholar Stephen Langton, as Archbishop of Canterbury in 1206. The whole kingdom was then placed under a papal interdict, which meant that no English subject had access to the sacraments. No English subject, on dying, could be buried with Christian rites. This punitive strike by the Pope gave John a convenient excuse to confiscate more church lands and exact more money from the clergy. However, after 6 years of national misery, John capitulated. He not only allowed Langton to be installed as Archbishop, but he surrendered England to the Pope in 1213 as a papal fief, agreeing to pay 1,000 marks a year in tribute. That did not go down well with the barons. The last straw was a failed expedition to France in 1214. And having finally lost France and debased England, John was now in danger of losing his English kingdom as well. In early 1215, the barons took up arms against him to enforce their demands for the liberty of the church and the realm. Now, the barons didn't at first seek to depose John, but rather a return to the rule of law. They sought a guarantee that the king would never again act outside the law or established custom, and also a written definition of what the relevant law and custom was. At the time of John's absolution in 1213, Archbishop Langton had insisted that he take an oath to observe the laws of the Anglo-Saxon king, Edward the Confessor, who died in 1066. Those laws had achieved a mythical significance as a supposed legacy from better times, though the text, entitled Leges Edwardi Confessoris, had in fact been concocted after the Norman conquest of 1066, perhaps as late as the 1130s, to foster a sense of continuity. The text said nothing of liberty or of the issues which concerned the barons. Its appeal in 1213 was symbolic, representing a desire to turn the clock back to a golden past. A more fruitful inspiration was the Coronation Charter of Henry I in 1100, in which Henry promised to restore all property wrongfully confiscated during the reign of his predecessor and to establish peace throughout the realm. More specifically, he promised not to take the profits of a bishopric during a vacancy, and that heirs should not have to buy back their inheritances. That charter was seen as a personal declaration of intent, which didn't extend beyond Henry's lifetime, but Henry's successors Stephen in 1135 and Henry II in 1154 both confirmed it. There's no evidence that Bishop I in 1189 confirmed it, or that John did so. So it must have seemed high time for it to be revived. Indeed, a contemporary chronicler reported that Archbishop Langton was responsible for rediscovering the Charter of 1100 and showing it to the barons in St. Paul's Cathedral in 1213, whereupon they all swore oaths to fight to the death for the liberties which it contained. Langton then acted as a go-between, attempting to achieve a peaceful settlement between the barons and the king. One of the first demands being a confirmation of Henry I's charter. But the 1100 charter wasn't sufficiently specific, and so a more detailed charter was proposed. And there followed over 5 months of negotiation with the king and the production of various drafts. Finally, on the 15th of June, the text of the Great Charter was settled at a place called Runnymede. This was an ancient meeting point in a meadow on the River Thames, not far from the king's castle at Windsor, and within a day's reach of the barons' stronghold in the Tower of London. Kings don't sign charters, but the agreed version was authorised by affixing the king's great seal in the presence of numerous named witnesses. Clerks were at once employed to make copies, all dated the 15th of June, which could be distributed through the kingdom. 4 of these original charters still survive, all of different shapes and sizes, but with exactly the same text. The charter was in no sense a written constitution. In political terms, it was a peace treaty with relatively short-term aims, although it was expected to bind the king's heirs as well. A striking feature was the level of detail represented by 63 clauses. They followed the scheme of Henry I's charter by first assuring the liberties of the church and then dealing with the protection of heirs. Next came widows. They were to have their own lands back without delay and without paying to redeem them, and no widow was to be compelled to remarry if she didn't wish to. The next set of provisions concerned taxation. No ad hoc tax was to be imposed by the king on feudal tenants, except by the common council of the realm, and other lords were not to tax their tenants at all, or to demand more service than was due. Procedures were set out for assembling this council of the realm. All bishops, earls and greater barons were to be summoned, and also all tenants-in-chief, on 40 days' notice, and if any did not attend, the business was to be done by those who did. Next came judicature. Common pleas, those which did not concern the king, were no longer to follow the king's court around, but were to be held in some certain place, as in the previous century. Financial penalties were to be proportionate to offences. The king promised not to appoint justices unless they knew the law of the realm and meant to observe it well. And all forests created in John's time were to be disafforested at once, and bad forest customs abolished. Tucked away among the miscellaneous provisions in the second half of the Charter was the stirring guarantee of personal liberty which was to resound down the centuries. No free person shall be taken or imprisoned or dispossessed or outlawed or exiled or in any way ruined, nor shall we go against him or put upon him except by the lawful judgment of his peers or by the law of the realm. To no one shall we sell, to no one deny or delay right or justice. No one has suggested a satisfactory reason why this was given such an inconspicuous position halfway through the Charter, as settled in June 1215, especially since in one of the drafts it had been placed first. Nor has it proved entirely clear what the words meant. Judgment by peers certainly did not mean, as was later thought, trial by jury. Trial juries were not used in criminal cases until ordeals came to an end, following the Lateran Council of November 1215. And in any case, jurors never gave judgments. They made findings of fact on oath, whereupon a court could give judgment. The probable meaning was simply that judgments should be given by someone other than the king. More puzzling was how judgments by peers could be an alternative to the law of the land, unless the word or could be read disjunctively, or even subdisjunctively, as and or. But the general sense was clear enough. Life, liberty, and property were not held at the king's pleasure, but could only be taken away by a court administering the law of the land. Perhaps the most remarkable provision in the 1215 Charter was the enforcement clause. The barons were to elect 25 of their number to maintain the liberties granted by the king, with the power to coerce the king, if necessary, by seizing his castles and lands. To all this the king gave his assent, backed by a solemn oath. No one can doubt the importance of this document, and yet it never became law. King John saw it as an abject defeat and had no intention whatever of observing it. He at once sent envoys to Pope Innocent III, who was now his feudal superior, to obtain an annulment. Now, that in itself was a breach of the king's oath in the Charter that he would never do such a thing, and that if he did, it would be void. But the Pope was pleased to oblige, declaring it shameful and demeaning for a king to make such concessions to his subjects. And by a bull dated the 24th of August 1215, he forbade the king to keep his promises on pain of anathema. The 25 barons, nevertheless, gave more weight to the king's oath and set about trying to depose him, whereupon the country descended into civil war, and the barons even considered offering the throne to the King of France. However, the situation completely changed the following year. by the sudden death of King John from dysentery, some suspected poisoning, in October 1216, when he was aged 49. And so ended the first phase of Magna Carta, a period of little over 1 year. It was not, as yet, a success story. Repudiated by the king and by the Pope, it had been largely ineffective. Now I must deal more briefly with the second phase of the story. The new king, John's son Henry III, was aged 9, and the government of England was now de facto in the hands of the leading barons. One of their first acts was to issue a new Magna Carta on the 12th of November 1216. Sealed by the king's chief minister and also by the papal legate, it was a charter no longer tainted by coercion or open to papal condemnation. But the content was scaled down in some respects. The provisions about the Great Council and the 25 enforcers were now dropped. The former was the nearest England ever came to a written parliamentary constitution. But the makers of the 1216 Charter were not concerned with future legislation or with taxation. They were simply setting down the old law as it was thought to be, and it was assumed that most of the provisions would be implemented promptly, since the implementation lay in their own hands. There was no need to establish a constitutional structure or an enforcement mechanism. Further revisions were made in 1217, accompanied this time by a separate forest charter, and then in 1225 the definitive fourth version was issued. It was still expressed as a charter of grant, but it was clearly more than just a concession by an individual king. It purported to have been issued in return for a tax granted to the king by the bishops, barons, and everyone of the realm. So this was, in effect, a parliament, and the 1225 Charter was later treated as the first Act of Parliament on the English statute book. In 1368, it was even enacted that any statute made contrary to Magna Carta should be treated as void, though this couldn't and didn't bind future parliaments, and I'm not aware that it was ever argued that it had done so. Thereafter, Magna Carta lost much of its impetus for 2 centuries. Lawyers didn't think of it as a constitutional document, except in a symbolic sense, but rather as a miscellany of technical provisions, many of them obsolete. And Magna Carta would probably not be remembered today, except by medievalists, were it not for its revival and reinterpretation in the later 16th century. It then became the legal foundation for Habeas Corpus, a procedure whereby anybody in custody could have the reason for his imprisonment examined by a superior court, which could, if it so turned out, release him. This became a powerful means of protecting the rule of law against new abuses of the prerogative, since all powers of government and taxation depended ultimately on imprisonment. Magna Carta then very quickly became a symbol of English liberty. It was pointed out that it had been confirmed over 30 times by successive kings, emphasizing that England was a limited monarchy. And in 1628, King Charles I was forced to reaffirm it by assenting to the Petition of Right. By then, Magna Carta was hailed as the law of laws, worthy, as it was said, to be written in letters of gold. According to Sir Edward Coke, everything that anyone has in this world, or that concerns the freedom and liberty of his body or his freehold, or the benefit of the law to which he is inheritable, to all these things this act extends. And that was far more than anyone could have imagined in 1215. But its mystical power was now indelible And so it was, 800 years later, when a copy of the charter was sent to Beijing for exhibition, and the Chinese authorities would not allow the people to see it. Not that anyone was likely to read it, but it stood for freedom under the law, something which an authoritarian regime could not tolerate.
Thank you, Mr. Baker, for your presentation.
Thank you. It was an intriguing overview of the Magna Carta and its fate, having in mind also the revival and the reinterpretation, which is common, I think, for most of the legal documents we are discussing today. For sure, in the case of the Hungarian Golden Bull, it's a very similar story. In later centuries, it was used as a tool in political and not only political debate.